Hey, what's going on, everybody? So, I wanted to provide some additional jury information which was not captured in the videos that I've provided thus far. So, this is another video that's going to talk about juries, but it may have some repeated information, but it also has information which I haven't presented before in this video series. So, check it out.
Before a jury is selected, the court and counsel will question potential jurors to ensure an impartial jury, as required by the Constitution. This preliminary examination is known as voir dire. If a juror is biased, counsel can ask the judge to dismiss that person for cause. There are also what are called peremptory challenges. In some criminal cases, this allows counsel to excuse a limited number of potential jurors without stating cause if the attorney believes a juror will not serve the best interests of their client, but a juror cannot be excused based on race or sex. In some cases, alternate jurors are selected to take the place of jurors who may become ill during the trial. Alternate jurors hear the evidence just as other jurors, but they don't participate in the deliberation unless officially replaced. Before the trial begins, the judge or the jurors will select who will serve as a foreperson. This person diffuses arguments, ensures each juror has a fair say, and addresses any necessary correspondence or questions to the judge. During the trial, jurors will hear opening statements from both parties on the reasons they are in court, testimony of witnesses, and evidence introduced, and finally, closing arguments. Throughout the trial, proper juror conduct is essential in order to be fair on all sides. In other words, jurors must not discuss the case and keep away from media, including social media. At the end of the trial, the judge will provide the jury with instructions and the final verdict is achieved. Unlike what we see on TV, rarely is there a hung jury or a jury that cannot come to a decision. If a jury is deadlocked and cannot reach a verdict, the judge will declare a mistrial and a new trial may take place. Jury service is a fundamental right guaranteed to all U.S. citizens. It is a civic responsibility that connects all of us, and it is one of the very important aspects of our democracy.
Okay, so that's it. So basically, you've just seen how juries members or potential jurors are actually eliminated from the case either through a peremptory challenge or by being questioned, and based on how they answer the question they can be removed. So just stay tuned, and we're going to have some more information coming up which is basically going to fortify what you've already seen. Hey, what's going on, everybody? So here's another video I found that talks about one of the processes for removing jurors or potential jurors from a case, which is called voir dire. And they're going to pronounce it a little bit differently, but essentially it's a French word. Basically, it means see and say. The word see, voir, je vois, I see, and the word say, dire, or je dire, say, basically, right? So here's a video. Check it out.
Many attorneys are always wondering what to do in voir dire. Now, if you're in federal court, the judge will do it and you can suggest questions. In state court, you need to talk to the clerk and find out what that judge wants, because in many instances the judge says, I want to do it, and I'll suggest the questions that I'm going to ask, and if you think there are any others that I'm not going to cover, then you let me know and I'll make the decision. And they limit the voir dire to a certain length of time. Criminal cases are different because people's liberty is at stake. They tend to let the attorneys ask lots and lots of questions. In civil, there are two issues that you always have to face. One is how much to tell the jury about the case, and the reason for that is you have to determine whether or not any of the jurors are biased or prejudiced, and if they are, there's going to be a challenge, which is going to be a peremptory challenge based upon the fact that there's cause, meaning there's a reason that that particular juror is incapable of making a truly independent judgment. And one example of that is in a criminal case where if you say as a defense lawyer to a prospective juror, the fact that the police arrested my client will not enter into your thinking. You can be truly objective about whether or not my client is guilty, and then when the juror says, well, the police wouldn't have arrested him if he wasn't guilty, and if you cannot dissuade the person from that and they cannot be objective, then that person would be dismissed for cause. But in terms of the questions that you are entitled to ask, you are not allowed to what's called condition the jury, which means trying to get the jury on your side by asking slanted questions. And so many times a judge will caution you against that by saying that you can ask general questions about the area. For example, if it's a breach of contract case, you can ask the experience that the jurors have in terms of what types of contracts they've signed, what their experience has been, whether there's ever been a breach, how they feel about people who breach contracts, how they feel about people who try to enforce contracts, which is very general. But you can't get into the very specifics about your agreement and say, well, if you were to hear evidence of the fact that so-and-so did X and Y, you'd consider that a breach, wouldn't you? Because now you're trying to condition the jury to your way of thinking, and the judges frown upon that. They want the jurors to have a tabula rasa, which means a blank, open slate in terms of considering the evidence as it's presented. Where you slant your evidence and where you tell the jury about your case is an opening statement.